Funding for the Think podcast comes from the City of Dallas City Secretary's Office. November 5th is the City of Dallas special election for multiple propositions, each impacting Dallas's future. Early voting begins October 21st. Information at dallascountyvotes.org.
Support for this show comes from Aon's Health Solutions. A thriving organization starts with a thriving workforce, but providing quality health and benefits today requires bold action. Aon is your ally in challenging the status quo. With predictive analytics to forecast your health risks, expertise to transform insights into innovative and financially sustainable solutions, and tailored strategies to meet the unique needs of your people and organization. The time for convention is over. The time for better benefits decisions is now. Visit aon.com to learn more.
When we hear about Supreme Court justices in the minority, we usually think about those on the losing side of a particular ruling. But these days, 5 out of the 9 individuals who sit on the high court and help make up the 6-3 conservative majority are numerical minority justices. So they were indeed confirmed by a Senate majority, but the senators who approved their nominations don't actually represent a majority of American voters. From KERA in Dallas, this is Think. I'm Chris Boyd. There is nothing illegal about numerical minority confirmations, but they may have contributed to some distinct mismatches between what American citizens say they want and what a handful of unelected justices say they can have under the Constitution. And my guest thinks the court has lost legitimacy as a result. Kevin J. McMahon is John R. Reitmeyer Professor of Political Science at Trinity College and author of A Supreme Court Unlike Any Other: The Deepening Divide Between the Justices and the People. Kevin, welcome to Think.
Great to be here. Thank you for inviting me.
You open the book by reminding us of the Dobbs ruling in 2022, which after almost 50 years of precedent declared that the Constitution, in fact, does not guarantee a right to abortion. Why was this the one that got many Americans wondering whether the court really represents their interests?
Well, I think most clearly, if you look at public opinion polls right before that decision was released, and people were asked the question whether the court should overturn Roe or keep it in place, a substantial majority of Americans wanted to keep it in place. So it was a court acting on a major issue, right, on a hot button issue, in a clearly in a fashion clearly inconsistent with the majority of Americans.
I've heard the argument that the court is not supposed to care what most Americans actually want, that it kind of floats above and it's there just to interpret the laws in light of what the Constitution says. But, I mean, does that convey the idea that we're all powerless in the face of this document written almost 250 years ago?
Yeah, that's an excellent point. I mean, I think we all learn, as you know, in elementary school or in secondary school, that the court is an independent body. It is separated from the elected branches of government. But as I argue in the book, historically, the court has actually been part of political regimes, right? So historically, we have tended to elect enduring regimes. So we tend to have a dominant political party that lasts for a very long time. So one example would be Franklin Roosevelt's Democratic Party. That Democratic Party won five elections in a row. And therefore, even though Franklin Roosevelt struggled with the court early on in his presidency, he was ultimately able to remake the court. And therefore, the court ultimately represents the wishes and the desires of the presidency and the dominant party represented by the president.
So did previous generations of justices pay closer attention to the will of the people, not just the will of the president, but the will of the people at whatever moment important decisions were handed down?
Not always, right? So sometimes you get you do have unpopular decisions by the court. That's certainly the case. But nevertheless, you do have the argument I make in the book is that you have a closer democratic connection because of the fact that these justices were representing the wishes of this dominant party, right? So again, so for example, in my first book, it's called Reconsidering Roosevelt on Race. The justices who struck down segregation in Brown versus Board of Education were really expressing the desires of the Democratic Party, at least the presidential wing of the Democratic Party, when they reached that decision in 1954.
Your concern now is that the Supreme Court faces a democracy gap. What does that term mean, as you have coined it?
Yeah, so what I mean there is that historically, you know, as you suggested in the introduction, historically, both the president and the Senate, which confirms the justices, have historically been aligned. So the president chooses the individual justices, and the Senate confirms those justices. But what we have today is this historical anomaly that five of the justices, the five most conservative justices, those who joined together in overturning Roe and Dobbs, are what I call numerical minority justices. So as one example, Brett Kavanaugh, when Brett Kavanaugh was confirmed, the number of senators, 52, who voted to confirm him, they collected 24.5 million fewer votes than the senators in opposition, right? So that is really a stark representation of this disparity between what the voters, who the voters are voting for, and who's on the court. So these numerical minority justices, these five are the only five in American history, and that is simply this inconsistent. So what I'm arguing is that there's a gap between the court and these democratic processes that endow it with legitimacy.
So I want to make sure I'm with you here. Those senators whose votes confirm a Supreme Court justice may come primarily from states with very small populations, but of course their votes in the confirmation process count just as much as senators elected by, very large populations, many millions more people.
Exactly. Yeah. So, if you have a state, so to some extent, this is just the nature of our of our constitutional structure. A state like Wyoming with about 500,000 people, they get 2 senators, those senators get to vote, right? A state like California, much larger population, they also get 2 senators. So, someone might critique this idea, but even if you take out or even if you focus on these bigger states, the 10 largest states, you still have this numerical problem with at least some of the justices that are in the majority.
Okay, we're definitely going to get to your suggestions in this conversation, but first I want to talk a little bit more about the way you say the democracy gap erodes the legitimacy of the court. Do you distinguish between perceived legitimacy, how much citizens in general trust in the court to do the right thing, and actual legitimacy, which is the right of any justice to a seat they've been appointed to and confirmed for according to the processes outlined in the Constitution?
Yeah, it's certainly perceived, right? It's this idea that in the past, and what I'm trying to do, and this is the reason for the title, the Supreme Court, unlike any other, this is not really a critique on the conservative nature of the Supreme Court. I argue that there have been other Supreme Courts that are deeply conservative, that were more legitimate, right? That this court is historically distinct in a number of ways, and one of which is this idea that the majority are numerical minority justices. So it is a perception. If we also look back to history, we'll see that sometimes when the court has felt itself out of line with public opinion, it's drawn back, right? It's been less aggressive on certain issues. So there is a possibility that this group of justices will do the same. Although if you look at this, these recent court these recent court decisions, including this one that just ended a few weeks ago, we see the court being pretty aggressive on some very important issues.
I mean, so much has changed politically in this country in the past, not quite century since the Roosevelt era, which you mentioned, including the extent to which the country is split almost down the middle, right, over which party's ideals are right for the moment. So presidents, it seems like, no longer win landslide victories now. Sometimes the popular vote and the electoral college vote don't match up. Why does that matter in terms of who sits on the Supreme Court and represents us?
Democrats have won the popular vote in 7 of the last 8 presidential elections, but 6 of the 9 justices have been appointed by Republican presidents, right? So there's sort of this lack of alignment that is different than in the past. As I said previously, in the past, you tended to have these dominant coalitions. So we have this new era of polarization. Why is this problematic? So let's just take a look at like the 1970s. You had these presidential candidates, Republican presidential candidates, who were winning massive elections. If you start from 1968 to 1992, that time period, everyone who won the presidency was a Republican, except for 1976 with Jimmy Carter. Not only were they were winning in great landslides. In 1972, Richard Nixon wins a 49 state landslide, more than 60% of the vote. 1984, Ronald Reagan wins a 49 state landslide, just under 60% of the vote, right? So these massive victories. But when they had chances to alter the court, when there was a vacancy and they had a chance to fill a seat, they often were unable to appoint the most conservative justices that they wanted. So they had a number of stumbles. Nixon had some of his nominees declined by the Senate. Same with Reagan. There were 2 reasons for this. One, a lot of times the Democrats controlled the Senate, and there was this filibuster, right? The filibuster was in place. So you needed really 60 votes to confirm a nominee. Now the filibuster is gone. You have these presidential candidates like Donald Trump winning without the popular vote, but having a more significant impact on what the court does, right? In terms of the ideology of the court. To me, that's democratically problematic. That in the past, when you have these presidents winning great landslides, they were less able to move the court in their direction, in their ideological direction, than a president like today who doesn't have those massive victories.
So in other words, there's no incentive necessarily now for presidents to have to make compromise choices.
That's right. Yeah, you tend to, as long as the president and the Senate are of the same party, the type of nominee, and this is particularly a Republican story, just given how few Democratic presidents have had opportunity to fill seats. As long as the Senate is aligned with the president, or the Republican majority in the Senate is aligned, in Trump's case, is aligned with the president, the nominee will be confirmed. So, back to Kavanaugh. It's somebody who was challenged as much as Kavanaugh was in terms of, this alleged sexual assault. In the past, that type of nominee, that controversial nominee, would not have won Senate confirmation. We have several historical examples where when the Senate's voiced displeasure, when a significant portion of the Senate voiced displeasure, the nominee was not confirmed. A number of things might have happened. He might have stepped aside. The president might have withdrawn the nomination. He might have lost in a vote, but they didn't become justices. But obviously, we know with Kavanaugh, he did become a justice. Why? Because his main audience, when he was given that testimony with his calendars in hand, right, and he was angry and sort of chastising the Democrats for their critique of or their highlighting of this event that took place many years ago, what he was doing, he wasn't really trying to convince the Democrats. He was trying to convince the president to keep him in place, and the Republicans in the Senate who were going to vote to confirm it. And he did that successfully.
Kevin, this brings us to the role, once again, of the Senate in confirming Supreme Court nominees. What do you mean when you describe the confirmation process in recent years as being, and these are your words, little more than theatrical?
Yeah. I mean, we see these hearings, right? And what you see is you get very similar questions. The Republicans, if it's a Republican nominee, are very supportive. The Democrats try to be a little hostile, but typically what the nominee does is any question that has the potential to reveal how he or she thinks on an upcoming case, they simply say, well, I'm sorry, I can't answer that question because it may become, might come before me. A case with these sets of facts may come before me. So I can't answer the question, right? So we don't really get any real answers. It really becomes a showcase more for the senators as opposed to the nominees. So we really don't have a full understanding of what the nominees believe. We can make guesses, and certainly senators and the public as a whole make assumptions about what these nominees will be like once they become a justice. But we really can't delve deep into their philosophy.
I mean, when you put it in those terms, it's interesting to think about the fact that there's probably no other job interview on the planet where when you are asked a direct question about how you would act in the job, you're able to demur and say, I can't possibly respond to this. Is there some legal reason that prospective justices are required to not directly answer these questions?
Well, it's based on this idea. John Roberts, the Chief Justice, used this idea, this not hypothetical, this metaphor, right? That they are like umpires calling balls and strikes, right? So the sense is that if they reveal their views on, say, abortion, they're not going to be objective evaluators of a case once they get to the high bench, right? So they're going to be biased in some ways, and they're going to sort of have to stick to whatever they said before the Senate Judiciary Committee. They're going to have to stick to that, and that means they're not, objective adjudicators of the law.
So you've said your primary concern is not that the court has specifically taken this sharp right turn in recent years based on that 6-3 conservative majority, that you would have perhaps written the same book if we had a runaway liberal majority based on the same methods of selecting and confirming justices. But how did it happen that the court has come to contain such an overwhelming majority of conservatives in an era of relatively weak Republican presidential outcomes?
Well, so part of this is a clear campaign on the part of Republicans, particularly, what's known as the conservative legal movement. As I mentioned previously, we had those Republicans at one point, 10 justices in a row were appointed by Republican presidents. Jimmy Carter, as I said, was the only Democrat, but there was no vacancy during his 4 years in office. So from 1969 with Richard Nixon's appointment until George H.W. Bush's appointment of Justice Souter, those were all Republican appointees. But in part because the Senate was, as I said earlier, in Democratic hands most of that time, and because of the filibuster, those Republican presidents chose questionable conservative or compromise candidates, right? Candidates in the case of, for example, Sandra Day O'Connor, the first woman to be a justice, who were called 80%ers in the Department of Justice. So what did that mean? That meant that the expectation of the Reagan Justice Department was that she would vote like along the lines of the president 80% of the time. And that turned out to be true, right? It turned out that on some of these key issues like abortion, she was unwilling to overturn Roe versus Wade, right? Roe versus Wade is 1973. The court has an opportunity to overturn Roe in 1992, the Casey decision. 8 of the justices at that time had been appointed by Republican presidents, and the one Democratic appointee was a dissenter in Roe. So there's this opportunity to overturn Roe in 1992, and the court doesn't do that, right? So what these conservative lawyers led by Leonard Leo in the Federalist Society did was they organized and they tried to identify individuals who would be committed to the conservative cause, and they wouldn't have to worry about individuals like Justice O'Connor, right, who might be with them, who might not be. So they worked very hard at identifying these individuals, oftentimes as early in law school, and when it came time to choose a new justice for a vacancy, Leonard Leo and the Federalist Society was very much involved. That was true in 2005 with the appointment of Roberts and Alito, and it was true with the 3 Trump justices.
How did the Federalist Society become such a powerful force in determining which would-be jurists are selected by Republican presidents specifically?
Again, a very good question. I mean, it's really doing the groundwork of organizing fellow conservatives, having conferences, talking about ideas, having an in with the administration in power. In the case of Donald Trump, for example, he basically passes off these decisions to the Federal Society and Heritage, right? That he asked them for a list of nominees that he's going to choose from. So that's much different than in the past. In the past, presidents knew the individuals they were appointing to the court. Oftentimes, these individuals were members of their administration. President Roosevelt played poker with some of the justices, right? They knew them quite well. In the case of Donald Trump, George W. Bush, oftentimes they meet these individuals for an hour before they make the appointment or a day before they make the appointment. They don't know them very well. It's basically, delegated to some other organization like the Federal Society to make these selections.
I mean, this past era, Kevin, where presidents typically knew in some kind of personal way or had worked with the Supreme Court candidates they nominated, I mean, it seems good and bad, right? Did that climate make it harder back in the day for women and for people of color to make their way onto the court because they weren't prominent in as many government positions?
Well, that's certainly true. I mean, this court, I call this a cookie cutter court, right? Because I suggest that the justices come from what I call the supreme elite. And so these justices come from, a very small slice of America. And one of the differences is that, for example, in the past, it was not uncommon for politicians to be appointed to the court. Somebody like Hugo Black was a sitting senator. Earl Warren was the former governor of California. He had been a vice presidential nominee, right? So that's a different type of justice that we don't see today. However, what we do see today, as you suggest, is a much more diverse court in terms of gender and in terms of race and ethnicity. So is that a question? Is that based on the way in which the process has changed, or just the diversity of America and the diversity of American politics more generally? I would suggest that it's more the latter, that this is about the diversity of American politics more generally, right? We didn't, just talk about the events of today. The fact that Kamala Harris is likely to be the Democratic nominee, well, that would be a new thing. We've never had a Black woman who's been a nominee of a party. So I think the diversity of the court in terms of race and gender is a reflection of American politics generally, and not specifically about the process in which justices are chosen.
Just to drill down a little further into this, selection mostly of people who come from the supreme elite, people may be listening and saying, well, Justice Thomas, Justice Sotomayor, their backgrounds are not of the supreme elite. But in terms of their education and then their subsequent careers, there's a pattern and they don't diverge from it.
Yeah, I mean, here's my best example. There are 37,000 high schools in the United States. Two of the justices went to the same high school, Georgetown Prep, right? I used to be able to say to my students that if you want to be a Supreme Court justice, you can go to any law school you want, as long as it's Harvard or Yale. No, Amy Coney Barrett went to Notre Dame Law School, so that's changed that for a while. But again, looking historically, we used to get justices from a much in terms of educational background, from a much broader array of schools. So another example, the last justice to attend a public institution of higher education as an undergraduate was confirmed in 1969, right? Last one who went to a public undergraduate institution. The last one who went to a public law school was confirmed in 1957. So what we have is so what's the reason for this? Well, one of the reasons why President Nixon's nominees were defeated, a couple of his were defeated, is in the Senate, was they were dismissed as for lack of quality, right? Well, it's an easy shortcut to say, this nominee attended Yale or Harvard Law School, therefore he or she is qualified, right? It's just easy. It sort of fits with our understanding of these institutions and the quality of these institutions. So it's much more difficult. An example of this is Harriet Miers, who was appointed by George W. Bush in 2005, who was dismissed, right? Because she was considered not a serious constitutional thinker. She didn't go to Harvard or Yale Law School. That was one of the easy ways in which you could dismiss her. And, again, this is what's striking about this is some of the great justices, some of the, historians consider great justices, didn't go to Harvard or law school, or Harvard or Yale Law School, right? They had a more individual experience, and their path to the court was much different than those who get there today.
Kevin, what is this checklist that the Federalist Society has in order to ensure that the people they recommend as potential Supreme Court justices have kind of the right conservative bona fides?
Yeah, so this is not a checklist that I found like in the papers of the Federal Society. This is basically looking at the types of nominees that were selected by Republican presidents. Again, this is basically a Republican story in terms of recent appointees. So again, what we were talking about earlier, how if you're a conservative group and you're very upset with somebody like Justice Souter, who people thought would be a conservative, he was chosen based on the understanding that he would be a conservative. But then he reaches decisions that are actually quite liberal, or at least moderate. But the most important decisions in terms of issues like abortion, he's unwilling to overturn Roe versus Wade. Well, how do you ensure that the next nominee that you have a chance to choose is going to be a true conservative, not somebody like Souter? And they actually had a name for this. It was called the greenhouse effect, right? And this doesn't deal with climate change or anything like that, right? The greenhouse effect is that a new justice will come to Washington and will think that he or she's a conservative, but once they get to Washington, they will want to have good press in the New York Times. And the longtime writer for the New York Times was Linda Greenhouse. The court writer for the New York Times was Linda Greenhouse. So the idea was that when they get to Washington, they want to be seen positive among liberal elites. So they will appeal to Linda Greenhouse, and this is the greenhouse effect. So how do you prevent the greenhouse effect, right? This is sort of the question that they're trying to answer. Well, what I argue is that they look to the model of conservatism on the court, and that's Antonin Scalia, right? So Antonin Scalia, appointed in 1986 by Ronald Reagan, confirmed 98 to nothing, right? Becomes really the face of conservatism on the court, particularly for his harsh dissents, but he's also known for having a great amount of charisma. He's funny. His best friend on the court was Ruth Bader Ginsburg, a liberal, right? How do you get somebody like Scalia? And basically, what this checklist is like, or where this checklist comes from, is trying to identify the next Scalia. If you would like to, we can go through some of those points.
Is there, Kevin, any kind of organization or effort to present very liberal candidates to presidents that has bubbled up from the Democratic Party?
Yes, there has been an attempt on the left to sort of, have a similar movement like the Federal Society, but it really hasn't taken much. It really hasn't gone anywhere, in all honesty. And people have really scratched their heads on why that's the case, but it just hasn't been as effective. That the Democratic presidents really haven't looked to it, and its leaders have not had such a central role as Leonard Leo has in Republican administrations.
Another phenomenon you describe in the book is that in recent years, like everyday Americans are paying attention to the actions of the Supreme Court in ways that previous generations may not have. Individual justices might be seen as superstars or as villains. Voters are instructed to elect candidates who might play a role in installing justices with certain ideological preferences. When did that start to be a major consideration in how we vote and something that all Americans are expected to pay attention to?
Yeah, so again, historically, the court would only pop up as an election issue occasionally, and we can, in terms of presidential elections, we can point to, say, 1936, when the court and Franklin Roosevelt, that was Franklin Roosevelt's first reelection campaign, and the court had struck down a lot of his New Deal legislation, the so-called First New Deal. So the court was obviously an issue there. In 1968, when you had a lot of disruption, rioting, and Lyndon Johnson had famously stepped down, not even though he was constitutionally entitled to run for another term, he chose not to. The court was very much in the conversation at that time as well. So there are certainly moments when the court has been an issue historically, but unlike today, where really the court has been on the top of the minds of voters in 2016, as you'll recall, in 2016, we had the death of Antonin Scalia in February of 2016. Barack Obama attempted to appoint Merrick Garland to his vacancy. The Republicans in the Senate blocked that. So we knew that the winner of that race was going to have a chance to fill Scalia's seat. And in 2018, we had a similar thing with Brett Kavanaugh had just been confirmed right before the election in November, the midterm elections. And importantly, a number of Democratic senators were trying to get reelected in red states that Donald Trump had won. So that issue was front and center. In 2020, we had the death of Ruth Bader Ginsburg in mid-September, right? Really, as people had started voting already, those who had the opportunity to have mail-in ballots, and the quick confirmation of Amy Coney Barrett. And then in 2022, we didn't have a vacancy or a new justice, but we did have the recent overturning of Roe versus Wade in Dobbs. So this idea of to what extent would that decision have an impact on elections was very important as well. This year, we'll see if the court plays a role. Obviously, the court, again, as I mentioned earlier, has issued some very controversial decisions, particularly on presidential immunity. My guess, once the Democrats get their ticket together, is that will be a focus. That it'll be a question of targeting Donald Trump and combining that with the opportunity that the court has seemingly given him with the presidential immunity case. And you'll also see abortion. Abortion is on the ballot in a number of states. There's a question that if the Republicans win both the Congress and the presidency, that they might have some national ban on abortion. Although former President Trump has certainly tried to alter the conversation a bit on this question. But so once again, this fall, well, maybe not as much as the last few elections. I think the court will be part of the conversation of the campaign.
I mean, this recent ruling that, grants presidents broad immunity from criminal prosecution for anything they do in the context of their job as president has taken many people certainly by surprise. It's kind of unprecedented in American history. I'm curious as to whether constitutional law and its history are taught to law students now in the same way it always has been, which is to say, generally assuming that what the court says contains great wisdom that needs to be sort of followed and carried into future generations.
Probably less so. I think it's fair to say. Yeah. I mean, the fun thing about teaching a constitutional law class is obviously these are very smart individuals. They put a lot of effort into their opinions. They have law clerks that they rely on, and law clerks are, recent graduates who are typically tops in their class. But what's really fun about teaching a constitutional law class is that a student will come to an opinion and read the majority opinion, and no matter the case, and be convinced that justice has the right answer. And then the student will read the dissent and start to think, well, maybe this justice has the right answer, right? So I think, well, as you're suggesting, traditionally students learn that sort of the doctrine, right? Meaning that what the majority has said, that this is the law of the land. There's always, because of these dissents and also often the quality of the dissents, that there's always been this questioning of whether the majority really got it right. So I think that tradition continues today.
And you think that's healthy for students to have a lot of questions as opposed to right answers as they're studying constitutional law?
Oh, I think it's fundamental, because instead of just having, the professor teach what the law is, right, that the students really wrestle. And what I tell my students is that they should become constitutional interpreters in their own right. Right. They should come to those opinions and consider, whether the majority got it right or the dissent, or maybe there's another way, right? Maybe they both got it wrong, and that there should have been a concurring opinion that offered another solution. So it's not just about learning what the court said. It's really about struggling and challenging themselves to understand what they think the Constitution says, how it should be interpreted, and what is, quote unquote, the best answer for a particular case.
You do propose in the book some potential remedies to this problem of a high court that lacks legitimacy with large percentages of Americans. How could we change the rules about how long any given justice might serve on the court?
Yeah, so there are various proposals about reforming the court. One of the one that's most controversial is packing the court, adding justices. We've had 9 justices for many years, but we haven't always had 9. We've had as many as 10 justices. To me, that's a problematic proposal, because my guess is you'd probably have one-upmanship. If the Democrats add 2 justices, once the Republicans get in power, they would add 2 more. But this idea of term limiting a justice, I think, is very attractive. And the most attractive proposal that I've read is an 18-year term. The court stays at 9 justices, right? And that there is a routine. Now, this will take some time, right? But there's a routine where every 2 years there would be a new vacancy. That's why you get 18-year terms, right? So 9 justices, every 2 years you have the vacancy. What this allows for is that when voters go to the polls, that they would know that if I vote for, Kamala Harris or Donald Trump, I know that these 2 justices will be leaving the court in the next 4 years. And I know what this candidate, what type of justice Donald Trump is going to appoint, or what candidate Kamala Harris is going to appoint, assuming she becomes the nominee, right? That this would allow this gap that I talk about, this democracy gap, to lessen. Compare that to our recent experience, right? Where Ruth Bader Ginsburg decided to stay on the court, right? She was clearly waiting for a Democratic president to get elected. She expected that to happen in 2016. It didn't. And she was hoping she could live long enough that it would happen in 2020. She died just before. If she had lived for another 4 months, right? She died in September of 2020. If she had lived until mid-January of 2021, Roe versus Wade would still be the law of the land, right? It would be reduced, but it would still be in place. Now that's there's sort of a strangeness about that, where liberals wake up every day hoping an 87-year-old two-time cancer survivor is still alive, right? That this doesn't seem this, one thing that Donald Trump had was luck in appointing Supreme Court justices. That to me is problematic for our democracy, and a system that seeks to rectify that is a very good one in my mind. And 18 years is also historically about the average term in which justices stayed on the bench. That's no longer the case, but for a long time that was approximately how long justices stayed on average.
So are these changes that you suggest, these would all require constitutional amendments, or could anything be achieved through legislation?
So court packing, adding justices could be achieved through legislation. And Franklin Roosevelt tried that in 1937. He wanted to expand the court to 15. That was defeated in the Senate, and that's why the court remains at 9. And that's one of the reasons why the court packing is more attractive is because it could be done legislatively and not through constitutional amendment. In terms of having a court in which there's a term limit of 18 years, it's my understanding that there is a legislative route to do this. So the justices would, and apparently the Biden administration is working on this, and Joe Biden teased that he was going to release something. Obviously, events have changed that, so we'll see if Kamala Harris takes that up. But that basically the justices who were the current justices would still be justices, but rulings would be decided only by the 9 most recent appointees. That's my understanding of how the legislation would work. So you wouldn't be removing a justice, right? They would still be there, but they would only be there sort of as an alternate juror for a comparison.
Just as an observer of the court and as an academic who has studied the court, do you think there's a limit to the size at which a Supreme Court can function effectively? Like, is 15 too many, or maybe you could go up to 21, or maybe it's best with 7? Do you have a sense of that?
Yeah, I mean, the court has been, the court is a very intimate institution, right? These individuals serve together for many years, currently 9. When they are in their conference room, it is only the 9 of them. There are no staff members. Justice Kagan tells us she was, for many years, she was the most recent appointee. And the job of the most recent appointee is, if there's a knock on the door in the conference room, it's the job of that justice, the most recent appointee, to go and open the door, right? So that seems to me that it's a court that size of 9 is one that works well. And that if after Brown versus Board, for example, you had proposals from Southerners who wanted to expand the court to 500, right?
Oh.
And what the
Wow.
idea there is obviously to make a court that doesn't work, right? To delegitimize it in a different way. So maybe you could go to 15. Certainly the court has had less than 9, as I said before. But 9 has had, obviously an odd number is best given that you have 5-4 decisions. It seems to me a number that has worked very effectively. So I don't see an overwhelming reason to change it.
Kevin J. McMahon is John R. Reitmeyer Professor of Political Science at Trinity College and author of A Supreme Court Unlike Any Other, The Deepening Divide Between the Justices and the People. Kevin, thanks very much for the conversation.
Thank you. I really appreciate it.
Again, I'm Chris Boyd. Thanks for listening. Have a great day.